Our next topic would be Articles 128 and 129 of the Labor Code. These provisions of the Labor Code deal with administration and enforcement of wage orders. Let's start with Article 128. Article 128, first paragraph, will tell you of the visitorial powers of the Secretary of Labor or its authorized or his authorized representative. Under the first paragraph, because you might be asked, distinguish visitorial from enforcement power of the regional director. They are not the same, they are different, although they are contained in one article. But visitorial power refers to the power given to the Secretary of Labor or his duly authorized representative, including labor regulations officers. We are talking here of labor inspectors. They shall have access to employers' records and premises at any time of the day or night, whenever work is being undertaken. And other than access, they have also the right to copy therefrom. Another one, to question any employee and investigate any fact or condition or matter which may be necessary to determination of violations which may aid the enforcement of the labor code or any labor law, wage order, rules and regulations issued pursuant thereto. So the visitorial power under paragraph A of the labor code gives the labor inspector, because normally it's the labor inspector who will visit and conduct the investigation, to go to the work premises and conduct investigation. They have the right to have access to the premises, access to documents, can interrogate, question any employee, get the statement, just to validate if it is true that the allegation of violations of the labor code or any labor law has been committed. So that's the visitorial power provided. So the labor inspector will go there, especially if there's a complaint filed by any employee that the employer is not paying the required or the prescribed wage rates. So that's as simple as that, the visitorial power of the regional director, who authorizes normally the labor inspector. So if you will be asked, you have to distinguish visitorial from enforcement power, because these two are distinct. Before the enforcement, the visitorial power must be exercised first, because how will you enforce if you did not find any violation? So there must be a finding by the labor inspector that there is violation. So if there is finding that there is violation, then the enforcement power will now be used. Under Article 128, Paragraph B of the Labor Code, it is provided that the regional director, through his authorized representative, have the power to issue compliance orders. So once it is found out by the labor inspector that there is violation of any labor standard provisions, then it will issue compliance order in order to enforce labor standard. The employer is given number of days to pay or to correct whatever mistake or non-payment of wages or the minimum wage as prescribed. In addition to that, the power to issue compliance orders, the regional director, through his authorized representative, can also issue writs of execution orders. So the employer who did not comply the wage or the minimum wage or other labor standard provisions, upon hearing or notice, hearing and notice, and it is found out that the employer did not comply, Then the Secretary of Labor or his duly authorized representative, in this case the Regional Director, shall issue the writ of execution to enforce the order. However, this cannot be enforced if the employer will contest the finding of the labor enforcement officer and raises issues supported by documentary proofs which are not considered in the course of the inspection. Another dimension or scope of the enforcement power of the Secretary of Labor or its authorized representative is the power to order stoppage of work or suspension of operation. Paragraph C, Article 128 of the Labor Code, it is provided that the Secretary of Labor and Employment may likewise order stoppage of work or suspension of operation of any unit or department of an establishment when non-compliance with the law or implementing rules and regulations poses grave and imminent danger to the health and safety of workers in the workplace. And within 24 hours, a hearing shall be conducted to determine whether or not the stoppage of work or suspension of operation shall be lifted or not. In connection therein, we have to look at Department Order number 183, series of 2017, Rule 8. It provides work stoppage order. This gives the implementing rules. Under Section 3 of that rule, the Regional Director shall issue the order lifting the work stoppage order upon receipt of proof and certification from the safety officer of the employer or duly accredited safety practitioner or consultant that the cause of the imminent danger has been abated. In addition to that scope, the power to issue stoppage of work and suspension of operation, there is a third dimension in the enforcement power of the Secretary of Labor through its authorized representative. This is found in Article 106 of the Labor Code, the power to restrict or prohibit the contracting out of labor to protect the rights of workers established under this code. The Secretary of Labor may do so or may prohibit or restrict, and he make appropriate distinctions between labor-only contracting and job contracting, as well as differentiations within these types of contracting, and determine who among the parties involved shall be considered employer for purposes of this code to prevent any violation or circumvention of any provision of this code. So that is the nature of Article 128. So for purposes of bar examination, since it is always asked, the visitorial enforcement power, usually you will be asked to define the visitorial power, the scope of visitorial power, and then also the scope of enforcement power. So that's how you will answer. So the scope of the enforcement power emphasize the three dimension. Again, to enumerate the three dimension, you have the power to issue compliance and writ of execution orders. The other one is the power to issue stoppage or suspension of operation if there's a basis or there is proof that the establishment's non-compliance poses grave and imminent danger to the health and safety of workers in the workplace. And the third dimension would be the power to restrict or prohibit the contracting out of labor to protect the workers' rights. That's the dimension of the enforcement power of the Secretary of Labor. That's Article 1 to 8. So that's how you will dissect it. So only in those instances that questions may be asked, which either define the visitorial an enforcement power or distinguish visitorial from enforcement power under Article 128. So it's now easy. The other power of the Secretary of Labor would be under Article 129. They have the power to settle money claims. So they have jurisdiction. We call it jurisdiction on simple money claims. Also in this case, you are going to group into two to simplify. There are two groups of employees mentioned here. As mentioned in Article 128, the domestic or household service or house helper. The complaint arises from employer-employee relation. So first, the jurisdiction of the regional director. When will the case be within the jurisdiction of the regional director? First, if it involves domestic or household service or house helper, and it arose from employer-employee relationship, then there must be no claim for reinstatement, and the aggregate sum of money of each employer or house helper does not exceed 5,000 pesos. So remember the requirements. In order for the complaint to fall within the jurisdiction of the regional director, the following requirements must be complied. It must be filed by domestic or household service or house helper under this code. And the basis of the complaint arose from the employer-employee relationship. There must be employer-employee relationship. Third, it does not include claim for reinstatement. Otherwise, it will go to the labor arbiter because there is already illegal dismissal. The regional director has no jurisdiction over illegal dismissal cases. And then the aggregate money claim of each employee or house helper does not exceed 5,000. When any of those requirements is absent, then it is now within the jurisdiction of the labor arbiter. Let's go to the second group. The second group would be employees outside the domestic or household work. We are talking here of ordinary employees. So if there is claim for non-payment of minimum wage and other labor standard benefits, it is not the labor arbiter that has jurisdiction over the case. No? It is the DOLE or the regional director, as long as there is no claim for reinstatement, because in that case it will be illegal dismissal already and it should be filed with the labor arbiter. So if it is outside household or domestic, if it is outside the domestic or household scenario, the requirement of the ceiling of the amount does not apply. So it's regardless of amount, even if it exceeds 5,000 for each employee, as long as it is and there is no claim for reinstatement. So this is part of the enforcement power of the Secretary of Labor, because it is their job under 128B or under 128B to enforce the labor regulations. So that is not the job of the labor arbiter to enforce labor standard. Okay, so let's look at the case. You have Jetro Intelligence and Security Corporation and Yakult Philippines Incorporated versus Secretary of Labor, August 14, 2009. In this case, the Supreme Court expanded interpretation of the jurisdiction of the regional director as to the amount of claims. According to the Supreme Court, if it involves employees who are not domestic or household workers, if they file non-payment of money claims or minimum standard benefits, it should be filed with the regional director, because this is the enforcement power of the regional director. not with the labor arbiter. The only instance when labor arbiter exercises jurisdiction over the case, according to Supreme Court, if there is illegal dismissal. Regarding the power of the regional director, or the jurisdiction of the regional director on simple money claims exceeding 5,000 pesos outside household service establishment. We have the case of Mr. Baladares et al. Versus Peak Ventures, June 16, 2009, where the Supreme Court discussed that it is within the power of the regional director to issue and enforce compliance order, or to enforce the labor standards. Now, the only exception is that when you divest the regional director of this jurisdiction, according to Supreme Court, is when the following elements must be present: that the employer contests the finding of the labor regulation officer and raises their own the issues, and that in order to resolve such issues, there is a need to examine evidentiary documents, and that such matters are not verifiable in the normal course of inspection. These rules also provide that the employer shall raise the objection during the hearing of the case or at any time after receipt of the notice of inspection result. With that, he will divest the regional director of his jurisdiction to hear and decide that simple money claim exceeding 5,000. If the employer will not exercise that discretion or that right, then the regional director can continue and proceed with the hearing of this case. You also have Jethro Intelligence and Security Corporation versus Secretary of Labor. That's the same ruling, more or less, showing that the expanded jurisdiction of the Secretary of Labor or the Regional Director when it comes to simple money claims outside the household service or outside the scope of household service. So employees who are asking for salary differential, and these employees are not hired in domestic or household services, they can file it with the regional director of the place or where their work premises is located. Now, when it comes to another issue, very important issue is whether or not the regional director, in the exercise of its power, visitorial power, have the right to determine employer-employee relationship. According to Supreme Court, in its conflicting decision in the Bombo Radio, it has finally settled that it is within the power of the regional director in the exercise of his visitorial power to determine the existence of employer-employee relationship, and it's not incidental as compared to its first ruling in the Bombo Radio. In the same case again went up to the Supreme Court, and the Supreme Court revisited its decision and changed its ruling that it's not anymore incidental. It is not an incidental power of the regional director to determine the existence of employer-employee relationship. It is within the power of the DOLE in order to enforce labor standard provisions under Article 128, Paragraph B. In fact, it is provided, the basis is that the Supreme Court cited the paragraph or the clause, in cases where the relationship with employer-employee still exists, so meaning they have to make the determination, and it must be respected according to the Supreme Court. Even the NLRC, it should not overturn the decision because it is part of the power. So that is the ruling of the Supreme Court when it comes to the determination of employer-employee relationship. So it's very important that the regional director, before exercising his visitorial and enforcement power, should determine the existence of employer-employee relationship. Logically, if there is no employer-employee relationship, then the labor code will not apply. So it's now very clear under Article 128, paragraph B of the labor code. This is now the expanded, this second Bombo Radio case contains the expanded visitorial and enforcement power of the Department of Labor. So far, when it comes to questions in bar examination, this Article 128 and 129 are popular sources of questions. So, questions that will be asked from Article 129 would be this jurisdiction as to simple money claims involving workers which are not hired in the domestic or household scenario, or they are not domestic or household workers. The only exception is when there is claim for illegal or for reinstatement, making it an illegal dismissal case. It will go now to the labor arbiter. Another exception to divest the regional director of its visitorial and enforcement power would be to contest the finding of the labor inspector and bring the case to the NLRC.